Welcome to our fourth lecture covering the Fair Labor Standards Act. In our first three lectures, we covered an overview of the statute and how minimum wages are calculated. And then we discussed overtime pay and how the FLSA exemptions are, what those exemptions look like. In this, our last lecture on this topic, we're going to discuss child labor laws, the Equal Pay Act, and the Texas specific statutes that relate to wage payment. So let's begin. So the FLSA does not have a lot of limitations upon child labor. You'll find many states have significantly more restrictions. Common things that other state laws provide would be more limitations upon the tasks that minors can do, upon the particular work hours that they can work, and many times those are connected to the school day or whether school is in session or not. And finally, whether a work permit is required from the school. For the most part, Texas doesn't have much additional regulation of minor employment. So we're going to be focusing upon the requirements in the FLSA. And so here's kind of a summary. Generally speaking, employees under the age of 14 can't be employed. There's a few exceptions, like being a newspaper delivery person, but for the most part, you've got to be at least 14 to be in the employment game. Generally speaking, 14 and 15-year-olds can be employed, although most employers won't hire them because, well, they can't be hired in anything that can be hazardous, and that's a defined category. We won't get into those specifics in great detail, but there are very limitations upon what they can do. But more importantly, there are very significant limitations upon the number of hours that these workers can work. And so most employers say it's just not worth the hassle to employ folks in that situation. So most employment really begins or becomes available to people once they hit the age of 16. At that point, there really aren't hour limitations in Texas or under federal law. Again, many states will have limitations, but not Texas. So just be aware if you happen to have a client who employs folks in multiple states, you really do have to get down into the weeds and figure out what the requirements are in that particular state. The real limitation for 16 and 17 years under federal law is that it can't be hazardous work. Now, how hazardous is defined is may not be the most intuitive. For example, they cannot operate an elevator. Now, you may think to yourself, elevator, that seems pretty safe. They're really talking about the industrial elevators where it's very easy to catch your finger in the kind of accordion style doors that are on those. They also cannot climb a ladder. Now that makes sense if you're climbing a really tall ladder, but actually the rule applies to very short ladders as well. And so if you are employing 16 or 17-year-olds, the supervisors need it to be very, very clear that even though a 16 or 17-year-old might feel very, very comfortable climbing a step stool or ladder that's 4 or 5 feet off the ground, that is prohibited, and that will get you into a lot of trouble really quickly. And finally, they can't operate a paper baler. This is obviously a very dangerous machinery. Relatively few places would have paper balers that a 16 or 17-year-old would be involved with. So probably the greatest issue is going to be the ladder. Now again, with the situation, the elevator, what you would just do is have the 16 or 17-year-old use the stairs instead of using the elevator. That can be a way of working around that. As we've talked about before, there are no limitations upon the number of hours that adults can work under the FLSA. And of course, people become adults at age 18, even if they happen to still be in high school. There are no requirements about the particular lunch breaks or other breaks that a person is entitled to have. Here are the limitations for 14 and 15-year-olds. Again, I'm not going to test you on these, but you do need to know that they're quite restrictive. So when school is in session, 14 and 15-year-olds can work no more than 3 hours a day between 7 and 7. So by the time they get off school, you can see there's hardly any more than 3 hours left before 7 o'clock. However, when school isn't in session, say spring break, winter break, summer break, they can work up to 8 hours a day up until 9 p.m. So really to employ people who are 14 or 15 during the school year probably doesn't make much sense. As we said, state law is going to, won't be federal preemption with respect to child labor laws. State laws that are more protective will control over federal laws. Again, some states require work permits. Typically, these issue from the high school. We don't have these in Texas, but it's very, very common. Even in states that, generally speaking, don't typically have a lot of employment regulation, you'll typically see that. As I said before, generally Texas child labor laws are not more restrictive than the federal law, and Texas does not require work permits for minors. Let's just go to this website right here for a second. It gives a nice summary, primarily of federal law, but also Texas state law. And you can see here, it goes through all of the ins and outs. They call it Texas child labor law, but it's really more of an exploration of the Fair Labor Standards Act than anything else. I'm not going to go through more detail about this. I just wanted to let you see that this is available on the Texas website. You can see this is the Texas Workforce Commission, TWC. This, by the way, is the FEP, or the 706 agency that we use for Title VII, ADA, and ADEA purposes in Texas. All right, so let's go back to our slides. So now we're going to talk about the Equal Pay Act. Now, of course, we've talked at length about the Equal Pay Act when we were in the Title VII sex discrimination section. You may recall the Equal Pay Act is from 1963. So this is before we had Title VII. This was kind of the Congress's first, big toe in the water type about discrimination. And because there was no Title VII to add Equal Pay Act to, they actually amended the Fair Labor Standards Act to include the Equal Pay Act. That's one of the reasons why the Equal Pay Act is a little funky compared to the other anti-discrimination acts, because it's part of a larger statute that really is designed to cover other topics. So while it was passed in about the same time period as the initial discrimination laws, it actually is part of the FLSA. And again, you've already probably have your definition in Quizlet, but if you don't, or you want to have a different one, here is one. So the Equal Pay Act, which is oftentimes called the EPA, doesn't stand, in our case, for Environmental Protection Agency, but it's kind of a common term. By the way, you don't need to know 1963. I'm just giving that to you so you have a sense as to the development of the law. And you can see with this law, it kind of makes sense that it happened in 1963 because the protections it provides are generally not as robust as we see in the Title VII, which of course is a 1965 statute. So you can see Congress was kind of trying something out, wasn't fully committed to an expansive statute. So anyway, under the EPA, men and women doing substantially equal work at the same employer in the same facility must be paid the same wage. So again, substantially equal work means you're doing the same tasks, not that it is of equal importance. For example, a person might say that a firefighter and a registered nurse do work that is equally important in that they are both involved in saving lives, right? But the actual way that the firefighter and the nurse save lives are very different. The tasks that are performed, the work setting, the employer who employs them, all of those things would be substantially difficult. So the EPA wouldn't apply in that situation. If you think in those terms, that's more of a comparable worth situation. And we don't have comparable worth in the United States. That's an EU concept. Awesome idea, but just hasn't made its way across the big pond, so to speak. So this is the Equal Pay Act. Again, both men and women can make claims under this statute. Obviously, most of the claims are from women. And again, if you want more information about the EPA, you can go to our sex discrimination claim. You may think to yourself, well, why do we have the Equal Pay Act and Title VII? Well, again, it's that historical reason. The Equal Pay Act provided some protection. The Title VII provided more protection. So you might think, well, why do we even care about the Equal Pay Act since we have Title VII? Well, one of the big advantages to the Equal Pay Act is that it has a longer statutory period. It uses the same statutory period that we have under the FLSA. 2 years under normal circumstances, 3 years in willful cases. Keep in mind, under Title VII, you only have 300 days, not even a full year, to file a complaint. So if you happen to be representing a plaintiff who is claiming sex discrimination, and there are some wage issues related to that, then obviously you're going to want to advance both the Title VII claim and the EPA claim, as well as any other claims you can advance. There's no reason not to advance the additional claims, even though probably the case is going to be more of a Title VII case than an EPA case. And here's just a discussion about the prima facie case. We've talked about the prima facie case lots and lots of times, but it's the same stuff we talked about before. You make that prima facie case. So the ball, the ping pong ball, starts in the plaintiff's side. Plaintiff makes the prima facie case. Then it goes to the employer side, and the employer is able to provide an explanation. Okay, yes, Sally does earn less than Bob, but Bob's been here longer. That would be a seniority argument. Or Bob is more productive. He makes 10 widgets an hour. Sally only makes 8. Or actually, that would be quality and quantity. Bob's appraisals are stronger, and the way that we've given Bob higher appraisals is in a non-sexist way, that it's looking at his performance overall. Then there could be some other factors. For example, perhaps Bob has more education or more experience before he went on board into this particular position. Those could be reasons that could justify the fact that Sally earns less than Bob. And again, as I said, or it could be the other way around. Bob earns less than Sally, and Bob could certainly advance his claim. So those are how the prima facie case works. Again, it's very, very similar to what we saw under Title VII. And as you can see in this, the Bob and Sally example, you need to have comparators. I'm sure I've given you a definition like this before, but this is the one for the EPA. People of the opposite sex who receive a higher rate of pay for performing the same work as the plaintiff. Now, obviously, comparators can be used for race claims under Title VII, for age claims under the ADEA, for national origin and other categories of claims. So obviously you would need to change some of this language here to reflect that. That's one of the main tools that both sides have, both the plaintiffs and the defendants have, to prove their case. So you almost always need to have comparators. You especially need to have comparators under the EPA. And again, comparators are going to be limited to people who work in the same establishment. And by that, I don't mean just the same employer, but I mean the same facility. So let's imagine that your client works for a Kohl's department store in Frisco. Well, you can't use the EPA to compare the wages in the Kohl's department store in Frisco to the Kohl's department store in Plano, even though they're owned by the same company, and even though presumably there's about the same cost of living in both places. It would need to be in that particular store. And even going farther than that, even within that store, there would be different positions. For example, the person who stocks the shelves might be paying a different rate than the person who runs the cash register. A person who performs the security actions, access store security, might earn a different rate. There might even be different departments within the store where people have different specialties. For example, in the lingerie department, you might have your staff be certified to fit bras, and they may earn a different pay rate than people in the furniture department. And the furniture department employees may receive special training so that they're familiar with those particular market concerns. It may also be that certain departments are paid on a commission basis and certain departments are paid on an hourly pay basis. Again, all of those could end up causing those not to be substantially equal work, depending upon the totality of the circumstances. So what does an employer do in this situation to make sure that you're not making yourself vulnerable to an EPA claim? And the way to do it is through a job evaluation process. And this needs to be an iterative process. You're going to constantly be doing this. You can't do it in 2020 and think you're done until 2040. It will need to be periodically reviewed. And a good process for this is to have each position kind of have a periodic review, maybe every 3 years, maybe every 5 years. And with the understanding, though, that there might be times where you have to speed that up because of technological advances or other issues, systems changes within the store. So what is a job evaluation? Well, it is a systematic process, typically done by HR folks, but you may have some line managers do it as well, for rating jobs in terms of these types of skills, and we'll go through these in just a minute. So you're going to want to be, again, very systematic about this. And if you're a large employer like Kohl's, you're going to want to go out to lots of different stores, because it could be that in one store, the position is done slightly differently than the way the position is done in another store. So you're going to want to get kind of an average with respect to that. And you're going to want to talk to not just one employee, but lots of employees. One employee might do things in a quirky way, and that's not what you want. You're going to want to talk to probably a dozen or more to get a complete look at that particular job. And you're not going to want to just talk to the employees themselves, but you're also going to want to talk to the supervisors. They may have a better understanding of kind of the complete scope of the job, at least in terms of the job evaluation. So if this is done carefully and periodically and in a kind of a dispassionate, kind of logical, systematic way, then it is very likely that the risk for a successful EPA claim will drop significantly. And of course, these job evaluations will be one of your main sources of evidence in the event that there is such a lawsuit. So you're doing it to avoid a lawsuit by making sure the pays are proportionate. But even if you still get the claim, you can use your evaluation as evidence of your process and your good faith in that process. So the things that you're looking at in this job evaluation are going to be skill, effort, responsibility, and working conditions. So for skill, it's exactly what you think it is. What does a person need to know and to do to be successful? So if I'm a cashier, one skill I'm going to need to know to do is how to make change, to do some simple arithmetic. I'm going to need to know how to run the cash register. I'm going to need to know how to run, if I'm at Kohl's, those ink things that are attached to expensive clothing. I need to know how to remove that without causing it to cause an ink spill on the clothing. I'm going to have some customer service skills to be able to diffuse situations, handle customer service complaints, how to handle returns, how to assist customers with discounts, with coupons, with things along those lines. So those would be some skills. Now, if I'm just stacking shelves, I probably don't need a lot of customer service skills. I mean, I'm going to need to know enough to get out of the way of customers. I'm going to need to know enough to say hi and may I help you and things like that. But, it's probably not going to be high stakes stuff. But I may well need to be able to fold clothes very, very nicely, to be able to do that and to be able to organize an area in a way that's attractive and that is placing things according to, they typically call them planograms, so that the display looks the way it's supposed to in the company marketing material. So those are skills that frankly the cashier doesn't need to have. And so I would say that a restocker and a cashier have very different skills. Now, it could be at Kohl's that the same person who's a cashier also functions as a restocker sometimes. And then, of course, that employee would need to have both sets of skills. So again, in smaller stores, you might need to have more Jacks and Janes of all trades and less specialization. Let's consider effort. How hard is it to do this job? Well, if I'm restocking, maybe I'm having to carry out heavy boxes to the showroom. Maybe I'm having to maneuver through tight rows and move things around and lift things and shift things and things along those bases. I'd say probably that role would be more physically demanding. But the cashier might be more mentally demanding, especially if you happen to have a string of customers who are not happy, who have complaints. That can be very tiring and very mentally draining for the person who's kind of maybe getting yelled at because of a customer complaint. And so there are different types of effort in this area. Responsibility, what is the scope of this person's area of a zone of domain of responsibility? If they are responsible for, let's say they are the lead cashier and there might be 4 cashiers that are going at the same time, but one person is there to handle the especially angry customers or to handle situations where there's a dispute about whether a coupon is valid or not or something along those lines. Well, in some senses, the skills are the same for the lead cashier as for the regular cashier, but the accountability might be very different. So responsibility might be greater. And the level of responsibility in terms of what decisions can be made may be different. Probably the average cashier has a limited level of responsibility. And so if a customer wants something beyond what that limited level of responsibility provides, typically that cashier is probably going to call a manager. And then the manager is the one that's going to be able to solve the bigger problem, perhaps, or at least tell the customer no, perhaps. And so the level of authority becomes an important issue in deciding the job evaluation. And finally, working conditions. Working, the night shift is a lot harder than working the day shift. Working in conditions that aren't air conditioned is a lot harder in Texas than working in air conditioning. Things like that can obviously significantly affect the job evaluation as well. So all of these are factors to consider when you are comparing positions. As you notice, one factor that's not here is job title. We're not interested in what the position is called. It's not unusual for it to have very similar jobs have different job titles. And that's fine if a company wants to do that. But at the end of the day, when you're doing the job evaluation, you may need to lump those particular jobs together. And so these are some things to keep in mind. Obviously, a very helpful tool in doing a job evaluation is a position description, so it's called a job description, that exists if it does exist. And when you're doing the periodic review, you're going to want to update possibly that job evaluation. For example, you may have listed as a skill the ability to make change, but your cash registers may now automatically spit out the correct change. Now, that doesn't mean that the person doesn't sometimes have to make change. I was at the Taco Bell recently, and I gave the cashier, I think it was something like, maybe I was being charged $8.52, and I gave the person, I guess, $9.02. And he was so addled by it. He didn't understand why I was giving him the 2 cents. And I was trying to explain to him I didn't want, 48 cents. I wanted 2 quarters. But that really threw him and what his operation was. So he actually, he took my $9 and he gave me back the 2 pennies and then gave me 48 cents, which was fine. But it was an indication that he wasn't comfortable making change. And so even when you have the machine that will spit out the change, you still need to know a little bit about making change. But again, those types of technologies are designed to increase the accuracy of change making, but also to some extent to reduce the skill required there. So you can put people in that position who, maybe aren't mathematicians. Okay. So we've already talked about that prima facie case. Again, it creates that inference, that kind of first, okay, yeah, you got something here. You haven't proved your case, but we're interested. This is the first thing that has to happen. If you can't do this, you go home. There's no other option here. And then we have, again, the additional factors, merit pay, quantity of production, seniority, as well as some other factors. Let's talk about pay secrecy. Well, the National Labor Relations Act prohibits employers from having secret pay policies. That doesn't mean they don't still exist, but they are technically unlawful. And not just technically, but they're just unlawful. Now, in non-unionized facilities, people usually don't think about the National Labor Relations Act in great detail because it doesn't apply in most areas. But this is one area that applies. That part of that statute does apply in non-unionized workforces. Obviously, in unionized workforces, you don't have pay secrecy anyway because that's all part of the collective bargaining agreement. So if you are advising your client who has a pay secrecy policy, you want to suggest that they move that out of their programs. Employees should be able to talk about their pay amongst themselves. Now, most employees won't. It's really not likely that there's going to be a ton of talk. People don't like to talk about their pay, but they ought to have the ability to do so if they want to. Again, if they can't talk about their pay, the idea is that they're not going to be able to see these differences. You may recall our earlier discussion about the Lily Ledbetter case, and it was because she didn't know what her coworkers, her male coworkers, had been earning for all those years. That's why she wasn't able to file her lawsuit until years after the fact. And so that idea is what prohibits the pay secrecy policies. So now we have completed the FLSA. Congratulations. We're now ready to move on to the Texas wage statutes. Yay. So this is the Texas specific stuff. Again, every state's going to have its own version. Some won't have any more than Texas has. Other states will have dramatically more significant amounts. So you don't assume that the state that you're providing support to a client for is going to be like Texas. So again, we've already talked about this a little bit, but a little refresher. Just like under federal law, Texas law does limit what 14 and 15-year-olds can do. Very few limitations on 16 and 17-year-olds, other than a few tasks that are considered hazardous. Texas does not require a work permit. And here we have the actual statute. I'm not going to go over this because this tracks very closely with the federal statute. If anything, it's less protective than the federal statute. So generally speaking, we think about the federal law with respect to child pay in the state of Texas. Okay, so let's talk though about putting aside the whole child pay side of things. Let's talk about the rules for all Texas employees. The first is if the employee is exempt or salaried, and this exemption test is what we talked about back here. Let me just flip here. When we're talking about exemptions to the FLSA, if a person is a professional or an executive or an have the administrative exemption, in those situations, they have to be paid at least once a month. Okay? But if they are non-exempt, in other words, they don't fit into those exceptions, they're perhaps paid hourly, they could be paid on a commission basis, they could be paid on a piecemeal basis, piece rate basis, then they're considered non-exempt. Again, this is that double negative. They are not, it does not apply to them. They have to be paid at least twice a month. And again, Texas employers are required to put up a poster. We've talked about the posters that are required earlier in other lectures. This is a Texas specific poster. And typically companies that oftentimes will hire or a company will have these posters already prepared. And there will be they're oftentimes called all-in-one posters. So you'll have the federal all-in-one poster and the state all-in-one poster. And the federal all-in-one poster will include the OSHA stuff, the NLRA stuff, the polygraph stuff, the Title VII stuff, the ADEA stuff, the ADA stuff, and I'm sure the USERA stuff, and I'm sure there's some other stuff that I'm not thinking of. If you were to just try to remember all the different posters and keep the latest versions, it would be a deal to do. So why not just buy a nicely laminated one-stop shopping poster? And then the Texas poster, or whatever state you're in, because there's obviously 50 of them, I guess there's probably more than 50 because you've got DC and Puerto Rico, but in any event, your state poster is going to include things like your payday, your child labor requirements, things like, the federal all-in-one is going to have your FLSA and your child labor requirements as well. So you're going to have to designate the paydays in the poster that you're going to post in the area. Now, the all-in-one poster probably has some areas where you can write in the paydays, but sometimes people actually do a separate poster for that as well. Now, if you don't want to pay for the slick, laminated, pretty posters that the services will provide, you can just go to the websites of all the various government agencies and print them out for free. But they won't be pretty. They won't fit, neatly together. It'll be a little bit more of a hassle. So again, here are our rules, and this is the actual statute that the rules I talked about here comes from. Exempt workers once a month, all other workers at least twice a month. And you have to post the dates that you're going to pay your folks. The general rule is that you should pay people the 1st and the 15th. about equal distance through the month. So if you're paying twice a month, it needs to be about equal. Now, you can pay every week, you can pay every other week, but if you choose to do twice a month, you can't, have it be, the 30th and the 31st, or I guess let's say the 29th and the 30th. Let's talk about when an employee ends his or her employment. So when he or she resigns, there are no special rules. You just pay them whenever you would have otherwise paid them for their next day. And you can pay them earlier if you want to, but there's no need to. So let's say you pay people on the 1st and the 15th of the month. Somebody quits on, May 2nd. Well, you have to pay them on May 15th when they ordinarily would have received their next paycheck. If you discharge the person, then you have to pay them no later than the 6th day after employment has ended. So if you fire them on May 2nd, then our next day will be the 3rd. This will be day 1. And 4th will be day 2. 5th will be day 3. 6th will be day 4. 7th will be day 5. 8th will be the 6th day. So you have to pay this person by this day. So you can see if you pay the 1st and the 15th, you wouldn't be able to wait for the 15th to go ahead and pay this person. So you would need to cut an additional check under those times. Now this is an interesting point. It's pretty obvious, but I want to emphasize this because I've actually handled several payday claims under this particular requirement, and I want to alert you to some concerns that come up with this. Texas, it allows pretty much kind of any pay system. The only thing of it is it has to be communicated to the employee. And the best practice, although this is not statutorily required, is that you present to the employee what the pay plan is, ideally with an example, ideally written in very approachable language, and then you have the employee sign it and date it so that everybody knows what the pay plan is. I mean, that makes sense because you want your employee to understand how he or she is being paid, in part because you've designed this pay program to incentivize that employee to do whatever the things are you want that employee to do. But if they don't understand how they're being paid, they're not being incentivized to effectively. You also, though, want to make sure they understand their pay program because if there's ever a dispute, wait a second, I thought I was being paid this way. Well, let's look at our pay agreement that we gave you here and see what it reflects. And so if the employee files a wage claim, say with the Texas Workforce Commission, if you can pull out a document that they sign that clearly and unambiguously describes the pay plan, guess what? You're going to win in Texas. However, let's say you don't have this document. There's a very good chance you're not going to win because the hearing officers are going to be inclined to the employee's perspective. After all, they're going to say the employer could have given the employee a document, and you could be pulling that document out right now, employer, but you chose not to. And this employee was confused, and that's your fault because you didn't do a good enough job explaining it. Now, are sometimes those employees going to have been genuinely confused? Of course. Are there going to be times where they're not being completely honest? Perhaps. But again, the employer had the ability to avoid that effect by, putting it in ink and giving examples. So that's a very good idea. A couple of things to keep in mind if you choose to do this. And you don't have to do this if it's an hourly wage situation. I'm really talking about commission plans or things like that. But if you're paying someone an hourly amount, then it wouldn't be necessary to do this. But if you do have some kind of commission program, it's a good idea. And some of these can be very complex. For example, there might be a 10% commission on if they sell this item, a 5% if they sell this item, a 2% if they sell this item. Then what's the policy if the customer returns the item at some point? And it might be beyond that particular pay period. Is there going to be a deduction for that particular employee's next pay cycle or not? So you can see there's just a lot of issues that can come up with a commission pay plan. And so you want to make sure you cover all those ins and outs. But if you cover it, it's also a good idea to include at-will employment language in it. It can be just one more piece of that puzzle that makes it clear to everybody that there's an at-will employment relationship. Now, if the document simply covers the pay plan and covers nothing else, and it doesn't mention at-will employment, it would certainly be my position that at-will employment has not been changed as a result of documenting the pay plan. But again, better safe than sorry, better practice to dot every I and cross every T in that circumstance. So I think those statements would be best served with an at-will statement, just one simple sentence at the end. Okay, so here we go through the termination scenarios, and this is what says, hey, you know what? Whatever the agreement is between the employee and the employer, that's what's going to control and how those are going to be calculated. And this applies not just to commissions, but also to bonuses. And the bonuses are kind of especially sensitive because typically the bonus reflects work that that employee has done maybe for the whole year. And so it's not unusual. Let's say that you work all year, you're working towards that bonus, which usually maybe is paid out December 1st. Well, what if you get fired November 20th? You worked hard all year, but you were 10 days short of getting the bonus. And maybe you were fired to avoid paying you the bonus. You can see the issues that come up. And so it would be very helpful for the employer in those situations, if there's a bonus plan in effect, to explain, what date you have to be there. Is there any kind of proportionate payout that happens? Are you entitled to, 11/12 if you make it to 11 months or whatever the deal is? All of that should be very, very clear. That way you can avoid having to explain that, hopefully, to the hearing officer. And if you do, you have got a good explanation. So now we have completed both the FLSA and the Texas wage statutes. Here's a couple of reminders to keep in mind. It is important. It's boring stuff. It's unglamorous stuff, but it is important to have all of your clients' ducks in a row on a wage and hour system basis. Most of the time, getting in the weeds in this area is something that the HR department of your employer is going to do, unless it's a very small organization. And so typically in a law firm, you don't do a lot of the nitty-gritty stuff to be concerned about compliance. You get called when the lawsuit is filed, when it's too late to clean house. I mean, you can clean house so to avoid the future lawsuit, but you're stuck with the facts as they are now. But if you are in-house, either in the legal department or in the HR department, this is where you can shine. And that's really one of the reasons why corporations have legal departments, is to avoid the lawsuit. It's not just in employment law areas, but in other areas, to make sure there are systems in place so that everybody's doing the right thing and we don't have to worry about legal exposure in that situation. So the things that a well-administered wage and hour system is going to have is it's going to properly classify workers. And of course, here we're looking at exemptions. Is this person truly fitting into the professional exemption? Does this person truly fit into the administrative exemption, and so forth? And again, as positions change over time, you're going to need to change classifications in many cases. Are the hours being recorded correctly? Again, this is a Portal to Portal Act issue. Is there preliminary work that needs to be paid or not needs to be paid? And is overtime being calculated correctly? Break times. Again, this isn't so much of a legal issue in Texas because we don't have any required breaks, but it is certainly a morale issue to make sure that you're consistent in these areas and that you're providing breaks that will allow your workers to be efficient and to feel like that they are being respected and treated in a positive manner. And in other states, these can be statutorily required. It's important, of course, if the break is under 20 minutes, that it be a paid break. I hope that this presentation and the ones preceding it have been helpful to you. I thank you for your attention. As always, if you have questions about our material, please don't hesitate to pop into my office hours. I thank you for your attention and have a wonderful day.